Hi, this is Attorney Clay Dawson of the Dawson Law Firm. This video is about whether you should have a will. People will ask, Mr. Dawson, should I have a will? My question is, why? Well, many people believe that if they don't have a will, their property is going to go to the state. That's wrong. If someone passes without a will, their property will go to their heirs. It will go to their heirs through the laws of intestate succession. Intestate means without a will. So why do you need a will? Well, wills can do things that the laws of intestate succession don't. If you want to disinherit someone, you've got to have a will. If you want one heir to get more than the other, you've got to have a will. If you want to leave property to someone that's not an heir, then you need to have a will. You may want your wife to receive everything instead of having to divide it with your children. You may want your surviving spouse to have everything instead of your adult children. And in that case, you need a will. With a will, you can even create a trust so that anything you leave children will be held in trust until their 18th or 21st birthday or so on. All that being said, wills have an inherent flaw. They are static. By that, I mean they were made at a certain period of time, and they address the circumstances existing as known at that time. They don't change. You can try to anticipate consequences or changes, but you don't know. That will, unless you keep it current by modifying it through an attorney, don't try to do it yourself. If you try to cut someone out of a will with a pair of scissors, it's just going to revoke the will. If you draw on it, if you write on it, you're probably going to revoke the will. So you'll have to do it through an attorney, unless you're just somehow blessed with knowledge on how to properly draft a will. There are other ways besides will to provide your property to loved ones. Now, the laws of intestate succession, one advantage to them is they're not static. They speak to the time that someone passes. They address the circumstances then existing. So, making a choice between the two, or maybe you'll choose neither. Whether you have an estate, whether you have a will or whether you don't, there will be an estate. And guess what? That estate is not made for your loved ones. Estates are made for creditors. Now, you may not have any creditors now. You may be paid up on everything. But if you become ill, if you're in hospital for 3 or 4 weeks, you may have bills that insurance didn't pay. And all the stuff you wanted to go to your loved ones may go to creditors. There are ways to avoid that, and they're not illegal. The same lawmakers that gave us estates gave us laws where you can protect your loved ones. I'm going to give you examples. The most common example is a tenancy by the entireties. For instance, in North Carolina, it's very common to have husband and wife on a deed. And if so, when one passes, the survivor receives all the property. It goes to the survivor. Doesn't pass through a will, doesn't pass through an estate, just goes straight to the surviving spouse. That can be done to parties other than the spouse. For instance, if someone wants to leave the family farm to their children when they pass, instead of having it go through an estate, they might grant the children what is called a remainder interest and reserve a life estate for themselves so that they can live there as its owner for the lifetime. But should they pass, then it would automatically go outside of an estate to their children or whoever. Even personal property can be passed outside of an estate. The DMV in many states will provide titles to vehicles which will go to you during your life, and should anything happen to you, it would go to a named person. It could be a spouse, a loved one, or it could be anyone. Banks provide all sorts of survivorship tools. You can get a survivorship checking account, a survivorship savings account. You can get survivorship negotiable instruments. Those are great ways to pass things outside of an estate. Life insurance passes outside of an estate. So now the question comes, okay, I don't pass my property through will or interstate succession, I'm going to give it away another way. Before you do that, I want you to think long and hard. It's your stuff. You worked hard, you toiled, you sweated, you sacrificed for it. Why give it away? If you have a surviving spouse, you probably want your partner in life to have it. I can understand that. Probably your partner in life would like you to enjoy some of what you earn too. If you don't have a surviving spouse, then why give it to your children or anyone? You can't take it with you. And this deferred gratification thing that we were taught as kids, well, when does it become time for the gratification? How long are you going to defer? You've earned this. Your kids can earn their own. You did. You've earned it. Use it. Buy a nice car. Buy nice clothes. Travel. Eat at nice restaurants. But you want them to have nice things. I guess you figure they can't do it for themselves. But anyway, if you give it to them, here's what happens. Because I've seen it as an attorney. You're going to leave things to your loved ones, and you're going to expect that they're going to be happy about it. Very frequently, they're not. Very frequently, you leave one child $20,000, but they're unhappy because you left another child $40,000. Somebody gets $20,000 for doing nothing, and they're going to find a way to be unhappy about it. You'll hear other complaints too, like, well, mother gave you the china and I only got the silverware. Or daddy gave you the shotgun and I got the rifle. Or that kid that got the $40,000, they may be mad because they didn't get it all. And the money that they did get, how do you think they're going to value it? They paid nothing for it. Do you think they're going to treat it like it's worth more than what they paid for it? Than more than what it cost them? Or maybe they're going to spend all the money on things you would never have spent it on. Maybe they're going to give away things that you thought were precious or sell them and use the money for things you would never have wanted. So don't leave nothing to nobody. Don't leave nothing to nobody but bills. This is Attorney Clay Dawson of the Dawson Law Firm. Thank you for watching.